Hello everyone, my name is Ijeoma and this is my channel where I talk about everything HR related and its intersection with the law under the Naija HR Chic Series. Now, I finished up a two-part series where I spoke about my journey as a HR professional, what made me decide to do it, what was the turning point for me, and I shared a brief personal story about the cincha for me. But today I'm going to talk about the NECA circular on termination of employment. Now, the NECA, as we all know, is the Nigerian Employers Consultative Association. Like, it has been like the voice of business for employers since 1957. So this recent circular was released on the 1st of April 2021 to every member, and it was talking about the status of the law on termination of employment. Now, this was predicated on three recent matters that had been decided by the courts. One of them is Duru and Sky Bank. Second is Aloysius and Diamond Bank PLC. And the last one is Bello Ibrahim and Echo Bank. They were each decided in 2015 and 2018. Don't ask me why they are all banks here, but it's very instructive to know because most people do not know, especially employers, that gone are those days where you could just wake up in the morning and just feel because you don't like an employee's face, you just terminate, your employment relationship with such a person. Now, the law is telling you that that employee has rights to bring an action against you, especially if it was done without any justifiable reason. So permit me to read briefly from the circular. So he said the practice where an employer could terminate contracts of employment with or without reason, provided the termination is with notice or payment in lieu of notice, is no longer the position. Yes, we do this quite a bit. I've had matters where an employer just woke up and felt, oh, I'm sacking you immediately, without recourse to whatever clauses may have been in the employment contract between the employer and the employee, with a payment of so and so amount to say I'm taking care of your severance package. Or in some instances you hear where the employer terminates such a relationship with 2 months salary, the current month's salary, and in that fell swoop. So there's no notice period for the person in some cases to teach whoever is coming in to do his or her job. And now the law is saying that that's no longer the position. You just can't wake up and sack somebody. Yes, I'm using the word that we all know. Or terminate an employment relationship with an employee just by giving them notice that you are going to leave the services of the company. No, it is not that. You have to state reasons, which is what I'm going to briefly speak of today, where it says that in arriving at its decision, the National Industrial Court of Nigeria, which is like the court that has jurisdiction to decide labor matters, relied on their powers provided in the Constitution of the Federal Republic of Nigeria and the National Industrial Court of Nigeria Act to give effect to, of course, international labor standards and best practices, relying on Article 4, which spoke about the termination of employment Convention of 1982, number 158 of international. I'm going to practically just break it down in the description box, like of the circular, so you can read up, or I'll give you a link to where you can read up more about this. But in light of what I'm saying, seeing in this circular, what it's trying to say right now is, now more than ever before, as an employer, if you do not have an employment expert or a lawyer in your payroll, you might need to get one now more than ever before. You know why? The last paragraph, which I'll read, says there's now an expanded jurisdiction of the National Industrial Court in determining this matter. So it means that you as an employer, you have to be diligent in making sure that every disciplinary record for an employee is documented, because this may come in handy just in case that employee decides to sue you or bring legal action against you in the future. And it also advises that more than ever before, you are advised or urged to be a little bit more circumspect in your dealings and your relationship with employees, so that whatever you do, if you decide to let go of an employee tomorrow, it is not for want of a reason or victimization, but because these are issues that the court can decide and say, okay, this employee was not let go with justifiable reason because he or she was doing something that they felt, oh, management did not like, and you will try to avoid these gray areas from happening as much as possible. So basically what this circular is trying to say is, if you are going to let go of an employee tomorrow, for instance, speaking from a HR perspective, right? The first thing is, okay, there's a known employee that is not meeting his or her targets. For companies that have performance appraisals, let's say every quarter, we have one-on-one sessions with your supervisor or your line manager every month, where goals and targets are set out for a certain employee to meet. So where this person has not met them, or for some reason there are things that he or she has done that are stated in the handbook. If you are a company that has one, if you don't have one, this is time you should have one, so that at least tomorrow nobody is saying, oh, we are letting you go because of certain things which you feel is constitutes gross misconduct, and it is not stated, it is not in written form. So these are things that will come in handy for you tomorrow. Let's just say an employee sues or brings a legal action to you. So what I was trying to say, like I said in the beginning, was, so if this person did not meet targets, you need to show that, okay, there was a performance improvement plan in some instances to make sure this person's targets were met, and when they did not meet them, this was the necessary action that needed to be taken. In some cases, or maybe the person was asked to go home, or asked to go for a training, or asked to be on suspension, depending on whatever the reason was. It has to be stated clearly, it has to be documented, so that tomorrow when, let's say, okay, we employ an employee or a worker, and the typical probation period for most companies is 6 months, and after 6 months it is stated in the letter that if you don't meet so and so target, you will be let go, because then you are looking at 2 weeks notice and all. So it's apart from the notice period which is stated, the person also knows that they have to live up to a certain standard, they have to meet certain targets, if not they will be let go. In that cases, depending on the circumstances of how the person was let go, they or may not be able to bring some action. Now let's now take it further to say this person was now confirmed after 6 months, and after 3 months there's another appraisal, and the person does not score very highly, depending on the type you use. And still put a link where you can get more information about performance appraisals and templates you can use if you don't have one. So but let it be based on his or her performance, not necessarily the person's attitude. Yes, the person's attitude, character and personality comes in handy for different industries. Let's say this employee, for instance, is manning a customer service desk. Of course their attitude is going to come into play, however subjective he or she thinks that is, it will go into, because there are, of course, a lot of companies have CCTV cameras stationed everywhere, so you can see where he or she is interacting with customers or with external stakeholders. That will form part of your reports to management, that this is the basis why he or she is scored a certain number on the scale for the performance appraisal, that sort of thing. But what this means is, more than ever before, you need to, if you were not documenting anything you did with your employees, you need to document them now. Because whether you like it or not, while we love the fact that the National Industrial Court is a little bit more tilted to cater to the rights of employees now more than ever before, you also have to protect yourself as an employer of labor. So let me know in this comment section what you think about the current NECA directive, or on the status of termination of employment. Do you think they are going too far? Do you think the National Industrial Court has too much jurisdiction? Do you think that if they keep expanding their jurisdiction, it's going to hurt employers, or it's going to hurt employees in the long run? Let me know what you think in the comment section. Hit me up. But please don't forget to like, share, comment. I need to hear what you think about what I've spoken to today. And most importantly, please don't forget to subscribe to my channel. I am at Ijeoma Ucheibe on YouTube, and you can also find me on LinkedIn. Let me know what you think. Till next time, don't forget to stay safe, guys.